ಎಲ್ಲರಿಗೆ ನಮಸ್ಕಾರ. ಇವತ್ತು ದ ಫೋಕಸ್ ಲೈನ್ಸ್ ಅಲ್ಲಿ ಸಮ್ ಇಂಪಾರ್ಟೆಂಟ್ ಎಡಿಟೋರಿಯಲ್ ಡಿಸ್ಕಸ್ ಮಾಡೋನು. ಸೊ ಇವತ್ತು ಡಿಸ್ಕಸ್ ಮಾಡೋದು ಅಂದ್ರೆ ನಾಲ್ಕು ಆರ್ಟಿಕಲ್ಸ್ ಇದಾವೆ. ಸೊ ಫಸ್ಟ್ ಆರ್ಟಿಕಲ್ ಇಸ್ ಅಬೌಟ್ ದ ಪ್ರೆಸಿಡೆನ್ಷಿಯಲ್ ರೆಫರೆನ್ಸ್. ಓಕೆ, ಇದು ಆಲ್ರೆಡಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದವನು. ಸೊ ಒಂದು ನ್ಯೂ ಡೈಮೆನ್ಷನ್ ಓಪನ್ ಆಗಿದೆ. ಸೊ ಇಟ್ಸ್ ಅಬೌಟ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕ್ಲಾರಿಟಿ ಆನ್ ದ ಪ್ರೆಸಿಡೆನ್ಷಿಯಲ್ ರೆಫರೆನ್ಸ್. ಸೊ ಇದು ಇನ್ ಡೀಟೇಲ್ ಡಿಸ್ಕಸ್ ಮಾಡೋದು ಇವತ್ತು. ಇದು ದ ಹಿಂದೂ ಅಲ್ಲೇ ಎಡಿಟೋರಿಯಲ್ ಬಂದಿದೆ ಮತ್ತು ಇದು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಫ್ರಮ್ ದ GS2 ಪರ್ಸ್ಪೆಕ್ಟಿವ್ ಫಾರ್ UPSC as well as for KPSC. Second article is again important from the GS2 perspective, and it is about the section 85 of BNSS, or the previously it was the section 438 in the CRPC. ಸೊ ಇದು ಇದಕ್ಕೆ ಏನು ಅರ್ಥ, ಇದು ಸೆಕ್ಷನ್ 85 or ಸೆಕ್ಷನ್ 348 and what are the judicial experiment. ಸೊ ಇದು ಬಿ ಡಿಟೇಲ್ ಡಿಸ್ಕಸ್ ಮಾಡೋದು. ನೆಕ್ಸ್ಟ್ ಆರ್ಟಿಕಲ್ ಈಸ್ ಅಬೌಟ್ ದ ಫೇತ್ ಆ್ಯಂಡ್ ಫ್ರೀಡಮ್. ಸೊ ಇಟ್ಸ್ ಅಬೌಟ್ ದ ರಿಲಿಜಿಯಸ್ ಕನ್ವರ್ಜನ್. ಸೊ ಕರ್ನಾಟಕ ಗೌರ್ಮೆಂಟ್ ಆಲ್ಸೋ ಒಂದು ರಿಲಿಜಿಯಸ್ ಕನ್ವರ್ಜೇಷನ್ ಲಾ ತಗೊಂಡು ಬಂದಿದ್ದವ್ರು. ಸೊ ಇವತ್ತು ಇದೇ ಆರ್ಟಿಕಲಲ್ಲೇ ಫೇತ್ ಮತ್ತು ಫ್ರೀಡಮ್, ಸೊ ಅದು ಕಾಂಪ್ಲೀಟ್ ಇರ್ತಿತ್ತು. ಮತ್ತು ಇದು ಇಂಪಾರ್ಟೆಂಟ್ ಫ್ರಮ್ ದ GS2 as well as ಫ್ರಮ್ GS4 ಪರ್ಸ್ಪೆಕ್ಟಿವ್. ಸೊ ಅದು ಬಿ ಡಿಸ್ಕಸ್ ಮಾಡೋಣ. ಲಾಸ್ಟ್ ಆರ್ಟಿಕಲ್ ಇಸ್ ಅಬೌಟ್ ದ AI and it is about the human cost. So ಇದು ಒಂದು ನ್ಯೂ ಡೈಮೆನ್ಷನ್ ಇತ್ತು. ಸೊ if you are not aware about this one, then you will get some very important information that is important from the GS2 as well as from the GS3, other science and tech plus GS4, that it is ethic perspective. ಸೊ ಇದು ಒಂದು ನ್ಯೂ ಡೈಮೆನ್ಷನ್ ಇತ್ತು. ಸೊ ಅದು ಬಿ ಡಿಸ್ಕಸ್ ಮಾಡೋಣ ಇನ್ ಡಿಟೇಲ್. ಸೊ ನೆಕ್ಸ್ಟ್ ಫಸ್ಟ್ ಆರ್ಟಿಕಲ್ ಡಿಸ್ಕಸ್ ಮಾಡೋಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. ಸೊ ಇದು ಆರ್ಟಿಕಲ್ ಇದು ಪ್ರೆಸಿಡೆಂಟ್ ರೆಫರೆನ್ಷಿಯಲ್ ಇದು. ಸೊ ದ ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಆಫ್ ದಿಸ್ ಆರ್ಟಿಕಲ್ ಈಸ್ ತಮಿಳ್ನಾಡು ಗವರ್ಮೆಂಟ್ ವರ್ಸಸ್ ತಮಿಳ್ನಾಡು ಗವರ್ನರ್ ಕೇಸ್. ಸೊ ಇದು ಕೇಸ್ ಹ್ಯಾಪನ್ಡ್ ಇನ್ April 2025. So that time Supreme Court came with one guideline that it has given 3 months time limit for the governor as well as for president to give assent on the bills. And ಆಮೇಲೆ in May 2025 the Honorable President of India has referred this matter to Supreme Court under the Article 143. So now the presidential reference andru ena. So presidential reference means under Article 143, President may refer any questions of law and public importance to the Supreme Court for its opinion, and it's purely advisory. Okay, so here one conflict arises that we will discuss. So why the constitutional clarity matters on this particular constitutional presidential reference issue? Because such references affect the separation of power. How it affects separation of power? Because if you see in this particular case, that Tamil Nadu government versus Tamil Nadu governor, what Supreme Court said, the Supreme Court given timeline for the governor as well as for president. But if you see, if certain this kind of timeline has to give, then it should come from the constitutional amendment. And the constitutional amendment, whose prerogative it is prerogative of parliament, but it is done by the Supreme Court. So there is the problem of separation of powers. Supreme Court is coming with a guideline, or Supreme Court coming with certain legislative power. So this is the separation of power in all. Second, it's about the federalism. How the federalism? Because if you see the particular matter, this matter, it is given the time limit for president to refer or to give assent on the bill where the state legislation or the state law involves. Okay, so it might arise the political problem because of the president, the Indian government belongs to different party and state governments belongs to different party. So and again it will create the problem of federalism, because many times you have seen the governor act as a tool or the agent of the union government. Okay, so there is again problem of federalism. Next is about a legislative executive checks and balance. So if you see what is the governor's assent. So governor is binding to give his assent on the bill unless it comes under his discretionary power. But if you see what is happening here, they are exercising this discretionary power on nearly all kinds of bill. They are many times they are willfully delayed, or they are exploring the other ways to how to delay the bill. So that time the executive and legislative, what was the check and balance, this discretionary power given to governor for the check and balance, now it is leading to the his discretionary or the his will whims, it is happening on his whims. So that is one problem here. Then what are the issues that raised in this particular editorial? It is about the scope of article 143. Why the scope of article 143? If you see the what article 143 talks, it talks about the question of law and the fact of public importance. Okay, it talks about this much only. So it is the vague. So what is the question of law? What is the fact of public importance? It is vague to interpret, and it is interpretation based on the executive. Okay, means the president, what he thinks, what he or she thinks that the particular case involves the question of law or fact. So he or she can refer to the Supreme Court. So it is again the vague. So this is the one concern regarding here. Second is about the transparency in this reference hearing, because if you see when it comes to the referential hearing, there is no clear procedure, or there is no clear grounds except this vague ground that on what basis or for what the presidential reference can be given to Supreme Court. Okay, so there is a question of transparency, how the procedure, how when the Supreme Court, the president will refer to Supreme Court, how the Supreme Court will take decision on it. Okay, so these are the vague issues are there. So there is matter of transparency also. Second, it is again there is conflict between binding nature and advisory nature. So many times what happens, this particular case, if you see, Supreme Court has given the binding decision on this particular matter, but if now the presidential reference has referred to Supreme Court, so the when it comes to presidential reference, it is advisory. Now the binding decision of Supreme Court as well as what they will give under this particular case, these two will come in conflict. So this is the one issue involved here. That's why the editorial says there is need of constitutional clarity, and it will again impact the legislative and executive power, because what will happen if the Supreme Court given verdict in favor of executive, then it will the hamper the power of legislature, or if give the direction or the verdict in favor of legislature, then it will hamper the power of executive. So there is again there will be impact on the legislature and executive procedure. Then next is the judicial efficiency or avoidance of overload. So what will happen if such kind of presidential reference the repeatedly the government is referring to Supreme Court, then what will happen? It will hamper the efficiency of judiciary, because already we have seen the 2 days back we were discussing in one case there where we have seen there were 85,000 cases pending here, and 3,000 cases increased from May 2025 to present day. In 3 months 3,000 cases increased. So with the this kind of reference coming again and again, then it will definitely hamper the judicial efficiency as well as it will lead to overload on Supreme Court. So this is the argument done by the editorial in this particular article. Okay, so we'll move toward the next article. It is about the judicial experimentalism versus the right to justice. So the context of this is section 498, okay, or IPC, or the in new section that BNS, it becomes the section 85. So it is enacted to punish cruelty against the woman in matrimonial setting. So the it is particularly enforcing the domestic violence. So it is talking about this particular issue, domestic violence, and this particular section given safeguard to women on the particular domestic violence. But what has happened over the time, the court flagged its misuse. So it led to misuse also. We have seen number of cases where this particular section used to exploit the husband. Okay, so this is the one misuse. So because of the false FIR, frivolous complaint, harassment of the husband and their families, so these are the misuse that you have seen over the time. Next, judiciary has tried to strike a balance. So they try to protect the victims of cruelty, also preventing the harassment of innocents accused. So this is the significant steps taken by the Supreme Court through various judgment, and this is particular aspect we are going to discuss in this article. So there are the certain cases. The most important is Allahabad High Court ruling in the Mukesh Bansal case. Okay, in this case, Supreme Court says it is the Allahabad High Court. It introduced 2-month cooling period after the filing FIR or complaint. Okay, so and this during this period there would be no coercive action against the whoever complaint has filed, maybe it husband or maybe it is the wife. Okay, so there will not be coercion action, including the arrest. So arrest also will not be done during this 2-month cooling period. Second, this time this case will be referred to the Family Welfare Committee, and this committee will work for the mediation. So it will focus on the restoration of conjugal bonds rather than the hampering. So for that purpose, will be referred to the Family Welfare Committee. So our social value may be uploaded in this case. Second, the Supreme Court also in Shivangi Bansal and Saib Bansal case. So they have upheld this particular 2 months cooling period, but it has again led to some criticism because it delayed victims' access to justice. Because in 2-month cooling period there will be no arrest, even the person is accused or person is guilty, then at that time the access of justice will be hampered. So delayed justice, denial of justice. So this thing will come, this issue will arise. Next is it fall outside the statutory authority or institutional framework. Okay, because this 2-month period, the institution, be it police, other magistrates, okay, or law statutory authority, the law is there. Okay, so the power entrusted the particular act on such authority, they cannot take action during this 2 months cooling period. So that time again the case will be delayed. So again it will lead to the fall outside of their authority. Next, it undermines the functioning of the criminal justice system. Because of 2-month period, there will not be any action taken. There would be no coercive action. So again, it will hamper the proper functioning of criminal justice system. Okay. So again, there are certain cases where this misuse of section 498. Okay. The Supreme Court has flagged this misuse. First is crucial case is Lalita Kumari case versus Government of UP. So here it said the preliminary inquiry is allowed in matrimonial dispute before the FIR registration. So this safeguard has introduced the preliminary inquiry before the FIR registration. So this is one safeguard introduced to avoid the misuse of this section 498. Then Arnesh Kumar case. Okay, or Arnesh Kumar versus State of Bihar case, they introduced principle of necessity for the arrest. Okay, principle of necessity means if the offense is serious or there is threat to victim, that time only the arrest will happen. Unless for 2 months cooling period, there will not be any action taken. Okay, so this is the previously introduced. Next, there should be checklist and notices of appearance before the arrest to prevent arbitrary arrest. Okay, so if some person has accused false under the false ground, then there would be some checklist or notices given to that person. Okay, so there should not be no arbitrary arrest. Okay, so this is one safeguard introduced in this Arnesh Kumar case. Next is the Satyendra Kumar case, or Satyendra Kumar Antil case versus CBI. It is strengthened the bail safeguard for the accused when the Arnesh Kumar guideline was not followed. So this is one more the safeguard introduced during this article. Okay, so again this particular all the safeguards through the NCRB report, you can see that it is worked effectively because the section 198, the highest offenses were there, the highest arrest offenses were there till 2016, but this arrest declined from the around 1.87 lakh in 2015. It had declined to the 1.45 lakh in 2022. So this is the serious decline, and the more this owes to this safeguard introduced by this all the cases. Okay, so it indicates the safeguard had impact on the curbing arbitrary cases or arbitrary arrests. Okay, so this is the positive impact done by this safeguard introduced by the Supreme Court in the various cases. But This is the one significant case where the Rajesh Sharma versus State of PP, where the judicial experimentalism was the dominant, because it directed formation of the Public Welfare Committee and cooling off period. Okay. Also, the direction under this one, it termed regressive and beyond judicial competence, because the Supreme Court, it don't have the power to introduce certain guidelines. It is the prerogative of legislature. So by boycotting this one, Supreme Court went to formation for the Public Welfare Committee, as well as it is introduced cooling off period. Okay, it was not present in law. Second, it is rolled back by Supreme Court within a year. Okay, in Social Action Forum for the Manav Adhikar, it was the case. So this was the development happened, recent development. Now this article talking about the what are issues that arise after these cases. Okay, so the issues is first is about the victims' access to justice. It is got delayed because of the cooling period. Second, it led to judicial overreach, because court started framing quasi-judicial committee, that is family welfare committee, and that committee has no statutory backing. So it is the quasi-judicial committee that framed by the Supreme Court, and it is against the separation of power. Second, it is come with conflict with legislative intent, because the criminal law reforms that already provided a checks. Okay, so there was the bail safeguard given, the preliminary inquiry that introduced, there were already safeguards present in the criminal law reforms, but this Arnish Kumar case, the bail safeguard introduced or the preliminary inquiry introduced in all these cases. Okay, this Lalita Kumari case, Arnish Kumar case, it is again made to duplication of efforts. So this is the one issue occurred here. Next, the denial of timely remedy, because it undermined principle of prompt justice, that is the justice on the time. Okay, so that is the one issue occurred, because it will leading to delayed of justice. Next, the section 498A, it was the originally victim centric, but subsequent debate or subsequent judicial pronouncement, what it lead, it is to prevent misuse or ensuring justice, it is made very neutral, and this neutrality of this particular section, it is the hampering the victim's capability to get justice. So this is the issue involved in this particular case. Okay, so there is the way forward given by in this particular article itself. So this article states for balance, it says there need of balance. So there is need of procedural safeguard for the accused. Okay, and but that procedural safeguard should not lead to victims' constitutional right to justice. It should not hamper the victim's constitutional right to justice. There should be safeguard, but ultimately the victim's right to justice should be prevail. Next, Supreme Court should revisit its ruling, because the concern of misuse already addressed through the legislative and judicial measures. So they need to be revisit its ruling. Okay, that given in the Arnish Kumar case. So this is the argument given by the this in this particular article, and that is what I wanted to discuss in this article. Okay, next about it is about the religious conversion. Okay, so the Supreme Court has issued notice to several states to file response to petition seeking to stay on operation of their anti-conversion or freedom of religion laws. Okay, so why this the particular laws challenged in Supreme Court? Because of these all legal challenges. Okay, so what are the legal challenges? Because these anti-conversion laws, they are made more stringent. Okay, the fine or the punishment under this particular act is very stringent. So this is the one issue. Then provisions make the bail difficult. It is impossible in interfaith marriage. So this is the one more concern. If person has involved in interfaith marriage, then bail is impossible. Okay. Next, it is also reverse the burden of proof. Previously, there was the burden of proof, the burden to prove that accusation. It was lied on the prosecution, but now it lies on the accused. No, he or she need to prove themselves as this as a innocent. Okay, so this is the one more issue involved. Then also the third parties, they are allowed to file complaints, because there are the certain third parties, maybe the other, like their neighbor or other interested party, religious active groups. Okay, now they can also go and file the complaints. So this is the one more issue involves, and that can lead to the political prosecution or the violence against the minority community or other community. So this is the issue involved here. Okay, next is about the constitutional or legal issues involved here. Okay, so all legal issues involve the freedom of religion, because the freedom of religion that given under article 25, it gives the freedom to practice their religion, but it is not give the right to convert people. Okay, so this is about the article 25, but at the same time it gives the people right to choose their faith. But the particular this the anti-conversion laws, they are against the freedom of religion. Next, it is against the equality before the law or non-discrimination, because of the reverse burden of proof. Okay, harsher bail condition. If you see other cases where the to prove the accusation, it lies on the prosecution, but in this particular case it lies on the accused person. So there is the no equality between the this particular act and also other act. So this is the one issue involved. Then again, there are certain person, the interfaith couple, the minority. Okay, they will be treated unfairly or discriminately. So this is the one issue involved, constitutional issue. Again, it is the issue of right to life or personal liberty, because under article 21, the fundamental right to choose companion or the right to marriage is given to the all the citizen, and this particular anti-conversion bills or the acts, they are against, they are violating right to life or personal liberty of the people. Next, the burden of proof. Just I discussed the in criminal jurisprudence, the norms that the prosecution must prove the guilt of the accused. But what in this particular act, the accused is constitutionally suspect made, because of the burden of proof lies on accused. So it will be, he will be constitutionally suspect. So or the this particular law is constitutionally suspected. Again, it is against the separation of power or procedural safeguard, because the third party will involves the it can file the complaint, and also it will the police or the other authorities got right under this one, they will decide on the these cases. So the whatever the judiciary used to take decision, now the taken by the executive. So this is the one issue involved here. Okay, next, the implications. What are the implications here, or why this matter occur? Okay, it poses serious challenges to interfaith marriage. The unity in diversity, where we have harbor the tremendous diversity or the discriminity is there. So the interfaith marriage is crucial to bring uniformity or the for the secular society, and this is the attempts will be curbed by this particular act. Also, it is against the personal liberty, because people are no longer free to choose their companion or exercise their right to marriage. Also, it will hamper the right of minorities. Okay, so there will be many times these acts used against the minority, so their right to freedom of right to religion, that will be hampered here. Okay, also it is need to lead to the misuse or harassment by the state or the non-state actor, particularly the religious group, extreme religious group. So this is the one issue. It also impact on religious observance or the church, other places of worship or assemblies, because we have seen several times this kind of assemblies will be targeted. Okay, it will many of the assemblies termed as it is attempt to convert the people. So under the lieu of this particular bill or the act, this kind of assemblies, religious worship will be reduced. Okay, or the will be prosecuted. So that is the one issue. Then also there are broader concern of secularism, religious freedom in India, because this particular act, which is hampering the religious secularism because of these factors. Okay, or the religious freedom because of these issues. So this is the issues involved it here. Okay, so this is all about this particular article. Now we'll move toward the next article. It is opening the new dimension of the AI, and it is very important from perspective of GS4. because UPSC repeatedly in 24 they asked question, and this year also in 25 they asked question on the AI. So from that perspective, this article is very important, and you will explore the new dimension here. So what we call AI, artificial intelligence or machine learning, we call them automated economies. Okay, they are producing efficient and nearly error-free outputs. But if you see, in reality, these technologies are heavily dependent on the invisible human labor, particularly from the, and this invisible human labor comes from the global south or developing countries. And these invisible labors, they are called as ghost workers, because they face exploitation, they work on the low wages, the poor working condition, as well as a mental health risk. So this is all issue we are going to discuss in this article. Okay, so next is where the human involved. Okay, we term AI as a independent or autonomous arena where it works, but there are the certain areas are there where human labor is still visible or the still very crucial, and without it the AI will not, the functionality of AI will be collapsed. Okay, so such areas, first is a data annotation or the labeling. So data entry or the labeling, this is the one area where human worker or the human needs. So workers, they label raw images, audio, video, text for the AI and or machine learning to train them. Okay, so training database, it is still done by the human worker. Now AI cannot understand that data without human tagged inputs. So this is the one more aspect where the human labor involved. Next is a content moderation. So if you see the content, human moderators, they filter harmful or sensitive content such as pornography is there, violence, the hate speeches. So it is done by the human moderators, not by the AI. The AI need to give certain inputs on this particular aspect, then only AI works. Okay, so this is one aspect. Then reinforcement learning, this is one more aspect where the AI is visible. So annotator, it provides the feedback on the AI model output. Okay, the AI model, to work on them, they give the output to them, it shapes them to be more accurate. So continuous, there is the process where the outputs given to the particular LLM model, so to make them more accurate. Okay, so there are some example like LLMs are the ChatGPT, Gemini is there, they require supervised labeling by human before the model become reliable. Okay, there is need of continuous improvement, the kaizen they call it. Okay, so this is where one aspect where human labor is still visible. Also there is the global supply chain of the human AI labor. So this is one more aspect, the supply chain, where it's not about the production, it's about the service also. In service sector, particularly the AI, there is a global supply chain. So it is mostly the outsourced to the developing countries. Okay, mostly the Kenya, India, Philippines, Pakistan. Okay, so here the AI labor is mostly outsourced. Also these workers are part of the hidden and precarious workforce that hired via subcontractors or the gig platforms. So this is the one more issue related to global supply chain of AI labor. Also these people works on the low wages, often less than $2 per hour. It is the below international standard. Next, the nature of work, it is repetitive, mentally stressed, it's something traumatic because of exposure to the violent and disturbing imaginary. Okay, continuously they need to work on this violent, all these kinds of aspect to feed give as an input, so it might hamper their mental ability or the mental health. And also due to repetitive work, mental state, it may lead to alienation from the society. So this is one more aspect, alienation from the work as well. Okay, next aspect involved, some are the challenges. First challenge is the economic exploitation. These workers often paid far below the international labor standard. So this is the economic exploitation you're talking. Most of the unstable contract companies that terminate the team, because these most of the contracts are the this work done by the gig workers, and we have seen the nature of gig working is the very unstable. So this is one aspect involved here. Next, mental health risk, because exposure to traumatic content, it will lead to their mental health illness, and also it will lead to the depression and anxiety. So this is one more ethical issue involves when it comes to the AI. Okay, next, about the working condition, there is long working condition. 8+ hour working condition is there. It will hamper their productivity, the deadlines given to them. Okay, so that would be very strict. So what will it will not completed within the seconds or the minute. Okay, they need to complete their task within the seconds or minute. So it will hamper their productivity as well as their mental health. Also, this worker lacks formal protection because being a gig worker, so the health benefit, grievance redressal mechanism, from this aspect they will be alienated. Next, it is lacks the transparency because the workers, they often don't know for what system their data is training. They will just mostly this contract these works outsourced and outsourced to subcontractors. So they will be finally they will be unaware about where the who for whom they are working. Okay, so this is the kind of commodity fetishism that Karl Marx says it is. Okay, so this is the one more aspect. Then again, it creates the ethical concern because of informed consent. They are no longer know that for whom they are training the data. Then again, it will lead to informed consent. Okay, so their problem of informed consent. Okay, so this is one ethical issue. Then other ethical issue involves about the labor right. Okay, the poor working condition. Okay, that consider modern day slavery. So this is one more ethical aspect. Also the global inequality, because the AI captured this AI, ultimately AI, it benefits the wealthy corporates or the developed country, but the other outsourced work it will done in developing country. So the burden borne by these vulnerable workers in the global south. So there is the global inequality. That is one more aspect. Then again, it will it has created legal vacuum. Okay, how the legal vacuum it is created? Because it lack of labor protection in digital economies. Okay, particularly labor protection is not available. Mostly the gig economy, there is no digital protection. Okay, there is no law, and existing laws are insufficient to regulate hidden AI labor. So we are getting to know this is the one kind of hidden aspect of AI. So the existing laws, they are not yet considered this aspect. So this is one issue. Again, there is issue of transparency because these AI companies, they project automation. Okay, but concern extent of the labor involvement. So there is transparency. The company says that they are doing it based on automation, but there are the labor involved in this aspect also. So there is a problem of transparency. Then what are the way forward that particular this article suggested? So there is need of labor right recognition. So this one more aspect here. Okay, so particularly in digital economy, there is need to uh, recognize the labor rights. Next, international labor standards. There is need of international labor standard for this AI worker. So this is one more aspect. Then there is need of transparency from the tech companies. So they should clarify whom they are giving contract, whom they are going subcontracts. Okay, and also the whether they are doing it automation basis or they are doing from the this human labor. So they need transparency. Also the national government across the world, they must update their labor and digital law, so to include this gig workers working in AI. So these aspects need to focus. So this is all about I wanted to discuss on this article. Next, we are finishing the discussion. Tomorrow we will meet where we will discuss the editorial that comes in the Hindu as well as the Indian Express. Thank you very much.